of this constitution that says that Arabic constitution. And I think that
movement as well as through
The cause of Palestine is at the heart of the creation of OIC in 1969 and remains its highest priority. 71st years after the Nakba, the Palestinian people are still waiting to return to their homeland. They are suffering on a daily basis from the consequences of an aggressive occupation and crimes perpetrated by the occupying power. Over all those years, Israel has continued to relentlessly act as a state above the law and bound by principles of international law without facing any consequences.
The adoption last year of the so-called Basic Law, Israel as the nation-state of the Jewish people, constitutes clear violation of international law, UN resolutions, and international covenants and agreements. It aims unequivocally to abolish the historical, political, legal, religious, and cultural rights of the Palestinian people, including the right of Palestinian refugees to return to their homeland. We forewarn in this regard against the danger of this Israeli racial law, which attempts to legalize racial discrimination based on Judaism, enshrine a legal Israeli colonial settlement approach as a national value, and undermine the status of the Arab identity and Arabic language of Palestinian citizens in general, denying the Palestinian people their existence, identity, and history and legitimate rights. Excellencies, ladies and gentlemen, the Organization of Islamic Cooperation would like to emphasize that the lack of effective international deterrent measures have emboldened Israel to pursue with total impunity racist acts and practices. Only accountability in this regard can create the necessary pressure towards ending the Israeli occupation and achieving the legitimate rights of the Palestinian people, the cornerstone for a peaceful and security in the Middle East. In this vein, individual and joint efforts in international fora, particularly the UN Human Rights Council, and concrete measures by the entire international community should include investigation of Israeli racist laws and adoption of binding resolutions that put an end to the racist and unjust Israeli occupation policies. The OIC, on its part, continued to exert efforts towards exposing the Israeli racist laws, policies, and practices to the world public opinion and pushing for adopting practical measures to ensure accountability for Israeli violations, crimes, and colonial policies, which continue unabated in blatant disregard for legality and morality. We reaffirm that the Israeli racist laws and practices shall never legitimize its injustice, aggressions, and violation of the rights of the Palestinian people, but instead render their confrontation an international obligation. In this regard, we affirm that for a just and lasting peace to materialize, Israel must end its colonial occupation, abolish its racist laws and policies, abide by the international references, and engage in a multilateral political process for achieving the two-state solution based on relevant UN resolutions and the Arab Peace Initiative.
Thank you, Ambassador, and thank you to everyone for being here. Good morning. So my research, as you've heard, and my work generally is on international law, public international law, and so my remarks will be relatively broad in terms of international law and legal obligations. The title is of the event is Half a Century of Occupation and Discrimination, and so yes, we could talk about half a century of occupation of the West Bank and Gaza, but really now we're talking about almost 3/4 of a century of discrimination in terms of thinking about the Palestinians more broadly. I was reading on my way over here yesterday a report by Hagar Shifaz in Haaretz last week about the lengths that the Israeli Defense Ministry have been going to in recent years to conceal some of the documentation of what happened in 1948, to remove or seal files in various historical archives, and not just concerning particular acts of violence within the war or the displacement of Palestinians at that time, but also documentation and evidence about the more structural and legalized aspects of the military government and the emergency law regimes that were instituted in Israel after that. So legal regimes to expropriate land and property from Palestinian refugees who'd been exiled, but also from Palestinian citizens who had stayed, to restrict their movement, to restrict their political participation, to infringe their labor rights, and so on. So a lot of this information is not new information. Obviously, Palestinian and Israeli historians and archives and testimonies have documented this for a long time, and these histories have been written, and they are also continuing histories of the present as well, which is relevant to our discussion today. So we can draw a direct line from some of these legal initiatives at the time to the structures of discrimination that we'll hear more about today. So the citizenship, immigration and residency laws, which remain the foundation of identity-based hierarchy in the legal system, and that were reinforced last year in the form of preferential citizenship status in the constitutional law, in the nation-state law, which Sausan will talk more about. The land law regimes, the planning policies, the physical segregation of the two main communities in Israel, in East Jerusalem and the rest of the West Bank, the separate civil and criminal legal systems and institutions for settlers and Palestinians in the West Bank, the entire settlement infrastructure and preferential services and resource allocations that we see there, and the blockade and the de-development of Gaza in recent years, right? So these are all factors that led to the Committee on the Elimination of Racial Discrimination finding in 2012 that Israel is committing violations of Article 3 of the ICERD Convention, which is the article that prohibits all policies and practices of racial segregation and apartheid. Many of those factors were also factors in the International Court of Justice findings in 2004, that the wall and the settlements and settlement infrastructure are illegal under international law, are tantamount to de facto annexation, are obstructing Palestinian self-determination, and must be dismantled as part of the process of decolonization. So we know all these violations of international law through this half century or these three-quarters century are well documented, well analysed by UN institutions and by international law authorities. And so the urgent question, I suppose, really is about how to change this reality of these violations, how to move towards a transformed reality closer to equality and justice. And so the one element of this which I'll focus on is the question of state and third state responsibilities for this under international law. So the interstate complaint to the third committee between Palestine and Israel, which was mentioned in the concept note for this event, is that's an opportunity for the Committee on the Elimination of Racial Discrimination to deepen its analysis of the Israeli policies and practices which it has expressed concern about in its country reviews consistently in the past, to expand further on the range and the implications of discrimination under Article 5 of the ICERD Convention, and to flesh out what it's previously found also in relation to violations of Article 3 by Israel, and what duties Israel has itself to cease these violations, but also what the implications are for third states in terms of their legal obligations. Because the prohibition of apartheid and segregation and systemic racial discrimination, these things are not just questions of internal affairs for the state itself that's concerned. These are clearly established as jus cogens norms under general international law. It's a peremptory prohibition from which there can be no exception, and so where it does exist, it creates an illegal situation, which is an issue not just for that particular state involved, but which gives rise to what are known as erga omnes legal obligations that are incumbent on all states. And the International Court of Justice, the International Law Commission have been consistent and clear on this. And so what this means in terms of third state responsibility under the articles on responsibility of states for internationally wrongful act is that a series of duties arise under international law for all states when you have a breach by one state of such a peremptory norm of international law, such as the maintenance of institutionalized discrimination, right? So in that context, all states have a duty not to recognise or accept as legitimate and lawful this illegal situation arising from such a breach. All states have a duty not to render aid or assistance in maintaining that situation, and all states have a duty to cooperate together to bring that illegal situation to an end, right? These duties are multilateral, they're imposed on all states, and they imply action being necessitated at multiple levels, at the political level, at the diplomatic level, at the economic level. And they extend to international organizations whose activities are determined or controlled by their member states, of which the UN is the most obvious example, but regional organizations obviously as well. This covers the acts and policies of those states and organizations themselves in terms of their relations with the state or states involved. The International Court of Justice has spoken about this in its advisory opinion on the wall. We've seen relatively limited actions towards enforcing that over the last 15 years. So it's clear that there's an onus on states and international organizations to do more on that front. There's also an onus on them in terms of the regulation of corporate actors in compliance with these international legal duties. And so in terms of addressing corporate complicity with the illegal situations, one of the most immediate and obvious steps that the UN can take in this regard is to publish the database of businesses operating in or with illegal settlements, and to ensure that all member states act upon it. It's been more than 3 years since the Human Rights Council mandated that database, and it seems inexcusable that it still hasn't been published. I'm not suggesting that in and of itself that will be a solution that will redress all of the illegalities, but it is an opportunity and a relatively unique transparency tool for compliance, control, and for enforcement of legal obligations, and it should be utilised as such. In the case specifically of the occupied territories, systematic discrimination is also considered to be an inherent violation of a people's right to self-determination. So along with military occupation, or along with colonial rule, the institutionalized form of segregation and discrimination that we saw in Southern Africa and elsewhere is defined and understood by international law as inherently infringing on self-determination. And so this connects the discussion today, I think, to a lot of the concerns and the discussions about the unacceptability of prolonged occupation and the concerns over annexation of territory that the Special Rapporteur, Professor Link, has been raising and warning about in his reports in recent years, and to the necessity of a process of meaningful decolonisation. And so I'll just conclude maybe with a few words on decolonisation more broadly, and in relation to a different, more recent International Court of Justice advisory opinion, which was the opinion from earlier this year on the Chagos archipelago, where the International Court of Justice found that decolonisation of the Chagos Islands is not complete, that continued British rule there is unlawful. And we see in that opinion the public international law elements of self-determination and decolonisation in terms of the restoration of sovereignty over the Chagos Islands to Mauritius, but we also see that combined with the human rights elements of self-determination and decolonisation in terms of the rights of the islanders to return to the islands and to their lives and livelihoods there. And so it's a strong guidance from the International Court of Justice on the width and parameters and extent of self-determination, systemic discrimination and decolonisation, and how these things interact. And the General Assembly resolution in May following on from the Court's decision sets out quite strong indicators on this in terms of Britain's obligations to withdraw, and the UN and its member states' obligations to oversee that and to expedite the process of decolonisation and dismantling of discriminatory regimes. It also shows us that decolonisation is not something that's in the past. It's still very much a live issue in many parts of the world and an ongoing struggle in many parts of the world, and that where there is evidence of systematic discrimination and violations of people's rights to freedom of self-determination, that the UN collectively and other international and regional organizations and their member states individually and collectively can and must act under international law and under their duties and responsibilities under international law to redress the violations that we see and to end systemic inequalities that exist and move towards more substantive and material equality in the jurisdictions and territories concerned.
I think that I will focus my presentation on the Jewish nation state law, which basically is not a law, it is a constitution. The fact that this basic law was confirmed during July 2018, as previously was stated, as a basic law and not as a regular law, this means that it has the status of a constitution. So we are not talking about any regular standard law, but we are talking about a constitution that Israel will apply and is applying not only on the area of 1948, which is Israel, but also it will be applied on every territory that is under the control of Israel, including the occupied Palestinian territories, West Bank, and including the occupied Syrian territory in the Golan Heights. In spite of the fact that this law, which I will detail a little bit more about its components, meets all the criteria of what institutional racism is based on the definition in the International Convention of the CERD, but in our opinion, in my opinion, it goes a lot more beyond what the CERD asserts to basically meets components of colonialism with characteristics of apartheid, whether inside of Israel and in the West Bank and in every territory that this law is valid or this constitution is valid and applies on. And this is the danger, basically, of this constitution. This is the only constitution that currently exists where it strengthens and enshrines the components of one ethnic majority, which is the Jewish ethnicity, making it superior over any other ethnic group inside the territory where this constitution applies. And I think that the fact, like one of the most positive aspects of this constitution is that we have all the time been arguing and trying to explain that the Palestinian people, wherever they are one people and are part, basically, of a result, basically, the division is a result of what happened in the Nakba in 1948. And Israel has all the time been trying to deny that. And this constitution comes basically and says that indeed the Palestinian people are one. It says it, of course, indirectly. It doesn't, of course, want to say it, but the meaning and the result of this constitution is that Israel views all Palestinians as one, however, applying on them different legal system and different constitutional norms. And Article 1 of this constitution explains why is it that I am saying that. Article 1A basically says, and I'm quoting, "The land of Israel is the historic homeland of the Jewish people in which the state of Israel was established." It continues later by saying, "The realization of the right to national self-determination in the state of Israel is exclusive to the Jewish people." This is one of the most, or basically the most important and dangerous articles of the Jewish nation-state law. Because first of all, it does not define the borders of Israel, but it actually says that in the land of Israel, referring to the biblical meaning of the land of Israel, which is Israel today and the West Bank, is defined as the land of Israel, and within it, the state of Israel was established. And why this is very important? Because basically, Israel in this constitution comes and say that the borders of the current Israel are still not definite until today, and they will expand basically until it reaches the biblical meaning of the land of Israel to basically be complete and apply all over the West Bank. And the idea behind this lack of definition or lack of asserting what the borders are is providing legitimacy and constitutional legitimacy to expanding more and more settlements in the West Bank without even basically giving the ability to make any counter argument against the expansion of the settlements in the West Bank. It clearly provides a political vision where not only the West Bank will be included one day as part of the state of Israel within the land of Israel, but it also basically provides a constitutional identity over all what will be defined as the state of Israel, not only today, but also in the future. The fact that there are a lot of components in this constitution, but I think that the fact that this constitution provides exclusive exercise for the right of self-determination basically says it all. You don't need to continue later with all the rest of the articles of this constitution. It's enough to come and say that the right to self-determination is given exclusively to the Jewish people in the state of Israel or in the land of Israel. And it affects Palestinians on both sides of the Green Line. It first of all affects the Palestinians inside of Israel who are citizens inside of Israel, but it basically creates a unique kind of citizenship where on the one hand Palestinian citizens are citizens because they are entitled to citizenship based on the 1952 Israeli citizenship law. But on the other hand, the constitutional status of their citizenship is not equal and is not acknowledged and is not included in the concept of we the people, which the constitutional embeds and includes. And we all know that constitutions basically are the document or are the political vision which define which groups are included within, are included as subjects of the constitution, are included as constitutional as the groups who are constitutionally acknowledged and included, which therefore enables them, gives them the legitimacy and the expectation to also not only feel but also expect the protection and the defense from the state wherever they live. This constitution comes and says to Palestinian citizens, not only you are second-class citizens, as we already know, but it is constitutionally legitimate to discriminate you. Because first of all, you are not included in the Constitution, and second of all, you don't have the right to have self-determination within the nation state that you are living, which means that the Jewish majority has the right, has the exclusive right to dominate, has the exclusive right to decide the destiny in all fields of right, whether who will own the property, who will own the, who will be able to to demand establishing towns, how they will also control the destiny of budget allocation. For example, they will own the destiny to determine they will have the ability to control the destiny in terms of who will determine the future and the political vision later on in the nation state, where some of the group Palestinians, which are known as a homeland minority, basically are excluded among it. Today, there is no constitution in the world that basically excludes and doesn't acknowledge and doesn't include and doesn't basically include all the groups that are citizens of one nation state, and therefore the result is that equality is no more a constitutional value, but discrimination is. And this has a lot of effects and dangerous impacts on Palestinian citizens, because it is now, after this constitution, it is now legitimate to discriminate against them. And not only that, it's encouraged even to discriminate against Palestinian citizens of Israel, because they are not part of the constituent, they are not part of the demo that the constitution applies on, they are not included in the constitution, and they don't even have the right to determine the destiny in their own homeland.
We meet at the most critical time since the founding of apartheid Israel in 1948, when both these issues have come into sharp focus more than ever before, because through passing of the nation-state law, Palestinians have been rendered as foreigners, or at best second-class citizens in the land of their birth, and apartheid Israel has passed into law the annexation of all Jerusalem as the capital of the Zionist apartheid state. This is the most manifestation expression of racial discrimination and the role of third parties, civil society formations, and NGOs is not a theoretical consideration nor an academic exercise. This is a reality we face. At the UN World Conference Against Racism, Racial Discrimination, Xenophobia, and Related Intolerance, held in Durban, South Africa in September 2001, there was a clarion call from the non-governmental organizations echoing the sentiments of many speakers, urging governments to drop their denial and equivocation and turn wholeheartedly to remedying racism and all forms of intolerance. The third parties, civil society formation, and NGOs were very clear in their articulation that hope, rhetoric, and apology were not enough. There is no substitute for action. So the question that emerges is what is to be done at this critical juncture. In occupied Palestine, the boycott, divestment, and sanctions, that being BDS movement, has shown us what needs to be done and has emerged as the third party or civil society formation that demonstrates the power of collective action. BDS has become the most painful thorn in the side of apartheid Israel. It is the best demonstration to have emerged since 1948 of the power of civil society formations in advancing the struggle for Palestine and the Palestinian people. Today, we have BDS-affiliated civil society formations on every continent in the world. The OIC, if it is true to its founding principles, must embrace BDS and provide institutional support in pursuit of its goals. In our own struggle in the Republic of South Africa, we recognized mass mobilization as the second pillar of the African National Congress pillars of the struggle for liberation. In the 1980s and 1990s, the emergence of the Mass Democratic Movement and the United Democratic Front, UDF, played a pivotal role in making apartheid South Africa ungovernable, conscientizing and raising awareness, advancing or advocating against racial discrimination, calling for the release of political prisoners. Particularly, the world rallied behind the Release Mandela campaign and the anti-apartheid struggle, and fighting the system of racial discrimination. Today, the remnants of that show of strength can still be seen when civil society formations, interfaith bodies, sports, cultural, and labor formations all respond in their thousands wherever the call is made to march in support of the Palestinian struggle. Increasingly, that is also manifesting in protests related in land reforms as we come to grips with the legacy of apartheid South Africa and its spatial planning. In 1996, my grandfather and the founding father of our nascent democracy and the global icon, President Nelson Mandela, said, I quote, "Non-governmental organizations played a pivotal role in the darkest days of our struggle against a racial discrimination and apartheid regime of South Africa," close quote. It is our moral duty, therefore, to support BDS and other civil society formations in fighting apartheid Israel and isolating it in the international arena. This is especially critical in the context of attempts to criminalize such support for BDS or targeting individuals or NGOs that support or are affiliated with BDS. Just in the last month, we have had incidents that demonstrate the desperation of apartheid Israel in imperialist sponsors and its lackeys. At the Open Source Festival that was held in Düsseldorf in Germany, one of my favorite African-American artists, Talib Kweli, was forced to withdraw because he would not denounce his association with BDS. Last week, the UK Lawyers for Israel attempted to intimidate Ismail Patel and the Friends of Al-Aqsa into not featuring any support for BDS at the weekend's Palestinian Expo, the largest expo on Palestine in Europe, which was held in London, featuring culture, technology, cuisine, and art, alongside a healthy political discourse on Palestine. Ladies and gentlemen, I will be failing in my duty if I did not address the elephant in the room. I want to say to you that the OIC cannot fail in its duty to rally all formations in government, business, and civil society to condemn the imposition of the deal of the century, which in fact I regard as the hoax of the century. I appeal to all organs of civil society, NGOs, interfaith bodies, and third parties to never allow the total liquidation of Palestine, and we must never accept the nefarious plan to annex all Jerusalem and the West Bank. Palestine is not for sale, ladies and gentlemen, and freedom, justice, and equality for all, and peace is non-negotiable. Perhaps the most fundamental role that third parties and NGOs and other civil society formations have played and continue to play is to raise the level of awareness and conscientizing the world about the racial discriminations that take place on a daily basis in occupied Palestine. We must, through our social media networks, build an international solidarity network that exposes the atrocities meted out against Palestinians, human rights violations, and crimes against humanity. We must define belligerently refusal for someone to return to his home and land of birth just because he is a Palestinian as nothing short of racial discrimination and a violation of human rights of 6 million refugees. The global campaign for the right of return has already received immense support from the global civil society movements, and we will continue to add our voice, particularly as South Africa, until this goal is realized. We must add our voices to the internal resistance who bravely and defiantly advocate for the release of political prisoners, particularly women and children, and fighting the system of racial discrimination. We cannot remain silent in the face of such atrocities, which my grandfather, Nelson Rolihlahla Mandela, coined the Palestinian struggle as the greatest moral issue of our time, yet the world remains silent. And when Palestinian children, some as young as 7 or even 8 years old are arrested. We must support campaigns for their immediate release. Finally, ladies and gentlemen, civil society formations and NGOs must continue to lobby forums such as the OIC, the International Criminal Court, and other structures of global governance to never acquiescent or compromise the just and principled struggle of the Palestinian people. Allow me, therefore, Program Director, to conclude with an extract from Sama Sabwari's poem, which is entitled, I quote, "Defying the Universe," where she asks the critical question, are your loved ones trapped behind the wall? Do they need the army's permission for their prayers to reach the sky? Must they always comfort you, even when the bombs are falling? Do you ever wonder who is walled in? Is it you, or is it them? And when it finally dawns upon you that their dignity sets them free, do you feel ashamed of your own liberty?
I will use two issues raised, and I will quote yesterday Prime Minister of Israel Netanyahu on the Twitter. He tweeted that archaeology DNA prove that Palestinians are not from Palestine, and the ancient Palestinians originally from south of Europe, and the current ones are from Arabia. And another interesting quote yesterday on his address to the Summit of Christians for Israel, Vice President of the States, Mike Pence, he said the following: "We stand with Israel because her cause is our cause, her values is our values, and her fights our fights. We stand with Israel because we believe in right over wrong, in good over evil, in liberty over tyranny." So this is what we are facing. I would like to thank you all, the audience, for your interest to attend this special symposium, and thanks goes to our brothers from the OIC for making this event possible, and the thanks for our distinguished speakers, panelists.
Dr. John Reynolds. Professor John Reynolds is eminent professor